If stabbing a rabbi who's sitting on the front stairs of a synagogue is not immediately considered a hate crime, then what is? I'm Yuda Katz. This is the Tribecast at tribejournal.org.
A rabbi stabbed several times in Brighton outside of a Jewish day school.
24-year-old Khalid Awad of Brighton will be held without bail.
Despite the pain from 8 stab wounds, he says he's thankful his attacker went after him to spare the lives of the children attending a summer camp at Shiloh House.
He want to kill me. I feel this. He don't want to go till he don't kill me. He tried to heal, to hurt, again and again and again. I try to, and Hashem make a miracle, and it finishes.
You knew this guy?
No.
Never once even?
No. Never.
If a rabbi sitting on the stairs of a synagogue getting stabbed 8 times is not immediately considered a hate crime, then what is? In the days following the arrest, there's been a lot of discussion on social media and amongst community members asking why this was not initially called a hate crime. It is expected that Suffolk County District Attorney Rachel Rollins will add hate crime charges to the case if she hasn't already by the time this episode is published. Our goal today is to better understand the legalities, timeline considerations, and procedures surrounding hate crimes in general, and especially as it pertains to apparently obvious cases like this one. To help us answer this question, we sit down with attorney Michael Thaler. Attorney Thaler is a former assistant district attorney in private practice since 2016. As a former ADA, he's prosecuted well over 1,000 cases. He's going to be able to help walk us through not just the legalities, but the procedures in which the prosecution looks at cases like this. We're including here the raw interview with attorney Thaler in order to provide the fullest picture possible. This was recorded before my interview with Rabbi Shlomo Noginski. As always, we hope you find this insightful. You can find us on social media at @tribejournal, and please consider joining us at tribejournal.org. Stay safe, folks. We're here with Mike Thaler from Thaler Law. Mike is a criminal defense attorney who's going to help us break down the idea of hate crimes, how it relates to actions that we as the general public would normally perceive as clearly a hate crime, and help us really understand the processes and procedures around the district attorney's office and the prosecution determining whether it's a hate crime and the different considerations around that determination. Mike, thanks so much for joining us here on the Tribecast.
Well, thanks so much. I really appreciate you having me.
Okay, great. So first of all, maybe just give us an overview what your thoughts are on some of the issues pertaining to the case that just happened literally right around the corner from me with the rabbi who was on the stairs of a synagogue and was stabbed 8 times. I think some of the facts that have emerged from the various investigative reports show that he was held by gunpoint. He was brought over to a car. He tried to give him the keys, wouldn't give him the keys. And then when the rabbi realized that this was going to be either a murder or a kidnapping and had nothing to do with the car, he made a run for it as far away from the school, at which time, once he realized that the perpetrator was going to actually catch up to him, this is apparently a trained black belt or something like this, and the rabbi was able to defend himself with his arm, apparently being stabbed 8 times, none of them fatal, until police officers arrived at the scene, and he pulled a gun on the police officer. Then from 2 separate, two different locations, the other 2 police officers told him to drop the weapon, at which time they arrested the suspect, who is now in custody and awaiting arraignment, I think is the right term, in the coming days. So from I would just say from the general public, especially the Jewish community, we would look at this as like, okay, you got a rabbi sitting on the steps of a synagogue Jewish school, and he was essentially, someone walked up to him with a gun, and then, when it's clear that it wasn't a car theft or anything like that, proceeded to try to murder this particular rabbi. Why is this not a hate crime? What are the different What are the different procedures? And help us break this down, unpack this baby.
Sure. And it's one of these things where it's early and most prosecutors, I was a prosecutor for a period of time, try not to jump to conclusions, especially because even though the media wants it, even though the public want it, it's difficult. This happened last Thursday. Thankfully, that Rabbi Noginski, frankly, is a hero. The fact that his first thought was to protect the people in the synagogue, not of his own well-being. And, from the information, as you said, that's come out there, and more information will come out. But the initial information, at least, is suggesting the person wanted to make him go in a van to kidnap or murder him when he recognized he needed to protect the people inside, and that this was a very risky circumstance. He made sure to get himself away from where the kids were. So obviously he was heroic in what he did, and thankfully is okay. I could tell you as well, from more and more information will come to light. But initially, this happened Thursday. They arrested him. They needed to have him arraigned in front of the judge in BMC in Brighton, which is the district court in Brighton, Friday morning. So the information that was presented to have him charged is not the information that will actually eventually be all the facts of the allegations against him. Oftentimes, Boston police will do shorter reports initially as they investigate. They just need to get him charged. He's facing 7 charges right now. He was arraigned on Friday, and the Suffolk County DA's office moved for dangerousness to have him held without bail. What that essentially means is they are arguing, and will almost definitively successfully argue, that this is a person who poses a danger to the community or to the public at large, or individual people specifically, that there is clear and convincing evidence that he committed some charges that meet the statute under the dangerousness statute, which is 276-58A, the chapter and section, and that there are no conditions of release that can assure the safety of the community. Initially, that hold would be for 120 days without bail. And right now, everything is still kind of delayed due to COVID, so 120 days will be longer than 120 days. They moved for dangerousness on Friday, and the hearing itself is actually going to be this Thursday, July 8th. Oftentimes, in these circumstances, they just put in the reports. They don't always necessarily have live witnesses, because that's the information they need to have him held. The reality is that it is hard for people, as much as everyone, it's seemingly obvious that there was a anti-Semitic component of this, but it's hard to just always jump to that conclusion, because you can't walk that back. He has 7 charges he's facing now, and I'll read them for you. These are all publicly available. Assault of matter with a dangerous weapon causing serious bodily injury. That is a maximum up to 15 years in state prison. Assault of matter with a dangerous weapon, 2 counts of assault with a dangerous weapon, 1 count of assault and murder, which is up to 10 years in state prison, attempt to commit a crime, and carrying a dangerous weapon on school grounds. I'm not sure if that's the knife or the firearm, but I would presume it's most likely to be the firearm. The reports there'll be more and more reports, but they need to get him charged. And then they're going to do a much more detailed investigation as the underlying basis for this. The hate crime statute in Massachusetts, at least for state courts, not attorney generals, it carries significant penalties, but not necessarily more than what he's already facing. They have to prove 3 things, or show 3 things. An assault and battery occurred, assault or battery, which is obvious. 2, it was done with the intent to intimidate an individual, and it's because of that person's race, color, religion, national origin, sexual orientation, gender identity, or disability. So the first one is obvious. The question is, was this done specifically because he's Jewish? Obviously, he's a rabbi on a synagogue. I think, I'm not sure what he was wearing, but it likely was relatively obvious to this individual of what the rabbi's identity is. But the question is that the reason this individual, Mr. Awad, did it, the defendant who's charged, or was there some other reason? If they didn't have that conclusively shown by Friday morning, the issue is if they charge it, one, they have to have probable cause that there's a basis to charge it. So there has to be something that they know by Friday morning in order to have him charged. And if they don't have it conclusive that is probable cause, the concern, I would presume, is often if you charge it and then in your investigation realize they probably don't have it, now suddenly they're telling the Jewish community, or whatever the racial reason If it's a different community that especially with the rise in hate crime violence involving all sorts of different genders and racial makeups, oh, never mind. This wasn't due to that. And then they feel like they have to owe an explanation. That's an issue. Especially it's an issue because the reality is you don't want to make things worse for that community. You want to make things better. The DA, Rachel Rollins, who I believe was present for the arraignment, she was present at the vigil. She's made it very clear she stands with the community and they're going to make sure this is investigated. But on Thursday, they're going to seek to have him held without bail for 4 months. And then the process would go down the road towards grand jury investigation. Grand juries have much more authority to seek records, whether it's social media accounts, phone records, or otherwise, to fully flesh out what was the motive here. Was there an animus involved? If so, additional charges could be brought in both the Brighton court or potentially go into Suffolk Superior Court and through the grand jury. Because oftentimes they charge stuff initially, and then especially when circumstance where it might not have been as clear what was the rabbi's long-term prospects from the stab wounds he suffered, if it becomes clear that he's going to have suffered further, there could be different kinds of aggravating factors where they could do additional charges. He charged assault or murder. They could change it to armed assault or murder through the grand jury process. If it's a circumstance that he suffers other kind of long-lasting injuries, they could change some of these. And if it's a circumstance that they do social media investigation, they see he's made different kind of threats, there could be additional charges there. So the long and short of it is they needed to get this person in front of the judge. And they had to put forward probable cause, which they did, of 7 charges. Even if they might have had it already at that point, given the obvious circumstances here, the rush to judgment can be a real concern if you have to walk it back. So I would suggest that is part of the reasons why they might not have initially charged it, even if it seems obvious, even if the information in the public viewpoint is that it's obvious.
Okay, so the short answer is that, and thank you for that in-depth answer, but the short answer is that if there's a religious figure on a place of prayer, that whether it be an imam, whether it be a rabbi, whether it be a priest, whoever it may be, the fact that during the what's it called? It's the arraignment. What is the technical term?
Arraignment is the first time you're in front of the judge. That's
right. So during the arraignment process, which is usually the next day, just because it wasn't classified as a hate crime doesn't mean that down the road it won't be added to the charges.
Yes, and the very obvious examples that are in the recent media, the shootings that occurred in Atlanta with the massage parlors. I believe, I'm not 100% on this, but I'm understanding I think 5 of 8 victims were Asian Americans. So there's obviously a rush to judgment. This is the reason why. It might be the reason why, but generally the prosecutors want to make sure they actually fully flesh that out because it's a very serious accusation, not necessarily a more punishable accusation. He's not actually, the hate crime statute wouldn't even be a more serious potential maximum penalty.
Maybe speak that out for us. It's a good segue. If it was a hate crime or they add that on, what are the additional penalties or consequences from the classification as a hate crime?
So the statute in Massachusetts is Chapter 265, Section 39, assault and battery for the purpose of intimidation. There are 3 different basically divisions of that statute based on the nature of the consequences. The 3 elements I mentioned before: committing an assault or battery with the intent to intimidate a person due to race, color, religion, national origin, etc. If that's the charge, it's a maximum 2.5 years in jail. Obviously, some of the charges this person is facing are a much higher maximum. So it's serious. It is an aggravating factor. So say, and these are not the correct numbers, say a judge was likely to give someone 7 years in prison. If this charge is there, if this reason is there, instead of 7, maybe they get 10. So even though the actual charge itself is a lower punishment, or maybe they get 7 plus 2.5. Even though the maximum they can face on other charges are more, it's an aggravating factor that likely raises what they're facing. And the other subdivisions is that's up to 2.5 years. and I do have the statute in front of me because I obviously want to make sure I get this 100% correct.
And just double check.
If that battery results in bodily injury, then it's a maximum of 5 years.
Okay, so there's a distinction. The first case of 2 years max, that might be like verbally accosting someone based on race, religion, gender, whatever it is.
More than verbally accosting, it has to be an assault or battery. Battery is an unconsented to touching. So even just a spit in someone's face is a battery, but that doesn't cause bodily injury. An assault, taking a punch at someone missing, but saying something racial related, that isn't causing bodily injury because you're not actually making contact. If you cause bodily injury, then it's up to 5 years. And if you do so while armed with a firearm, rifle, shotgun, machine gun, or assault weapon, which this individual allegedly was with the firearm, then it's up to 10 years or in state prison or 2.5 years in the House of Correction.
And these are all add-ons because of the hate component. Is that correct?
Well, this is the hate crime statute. If it's an assault or a battery with the intent to intimidate due to the race or religion, it's up to 2.5 years. If the person causes bodily injury in that act, it's up to 5 years. And if while doing so, the person's armed with a firearm, it's up to 10 years.
But when you say it's up to 10 years, like this case,
yes,
if it is classified as a hate crime, what does that mean? That there will be 10, 20, 30, 100 years based on the crime of attempted murder or whatever it may be. And then on top of that, it would be maximum 10 more years, or maybe just explain that.
So consecutive means one after the other. For also criminal purposes as well as normal layman's terms. Concurrent means at the same time. It doesn't. So he's charged right now with 7 crimes. It's not the circumstance that each maximum is one after the other. 15 years plus 10 years plus 5 years. He could get probation on one count, time on another count, and he could have a multitude of different options. If he was charged with the hate crime statute now, instead of 7 charges, he'd be facing 8. It wouldn't be the circumstance that necessarily this is consecutive. There are some charges that are on and after other ones. It could be the circumstance that on the aggravated assault and battery, dangerous weapon causing serious bodily injury, the maximum is 15 years. Say the judge were to give him 7 to 10, and again, he's innocent of proven guilty, but say he's found guilty or he pleads guilty, and the judge is going to give him 7 to 10 years. Because of this, it's not like he now gets an additional 10 or up to additional 10. He could, but it could also be he gets 7 to 10 on both of these charges together. It's an aggravating factor as well as a separate offense. The reason to charge these kinds of offenses are it gives you a motivation that was the underlying basis for the offense, which generally accentuates or it makes the penalty worse. Think of the Derek Chauvin trial. He got 22.5 years in prison. The guidelines call for a lesser sentence because of 2 different things. I think because of the nature of the allegations against him, which were proven to the jury, and because of the position of force that was used where he was in a position of authority as a police officer. Those were aggravating factors. State crimes, not as much, but federal crimes, there are aggravating factors in sentencing guidelines that result in higher penalties. If based on the monetary amount, based on the position of trust, based on whether or not you accept responsibility, it could eke up the guidelines one step at a time here and there. In the Superior Court, there are advisory sentencing guidelines in Massachusetts. They can depart up, they can depart down, they can stay within it. These are not correct numbers. But if the guidelines for this circumstance say it's 5 to 7 years, the prosecution asks, say, for 15 years. Some part of the explanation as to why it should be more is because of the hate crime component, which gives the judge a reason to bump it up. So that's sometimes the reason to do these charges aren't just because they are correct, because they believe they can prove it, but because it also can expose the individual in not just the eye of public opinion, but in the actual judicial process to a more serious sentence, not because this carries a higher maximum, because it makes the crime worse. Because, what we're saying before, it is obvious who this gentleman was, the rabbi. I'm sure it was obvious. But just because it's obvious that the person belongs to a protected class, doesn't necessarily make it obvious that that is the motivation. Otherwise, any crime against an individual who is gay, who is black, who is Jewish, would automatically be looked at as a hate crime. Just because they fit the class, the crime has to be motivated by that.
Okay, great. So let's drill down on that a little bit, because I forget who reported this. We can check the records, but it was reported by investigative journalists that it was that they interviewed the two roommates of this particular perpetrator, and they found that he oftentimes said anti-Semitic jokes. He actually was brought up on charges prior to this, battery being one of them. And how does that play into the determination of this as a hate crime?
Well, that certainly does, and I'm glad you brought that up. The reality is, unless someone explicitly says in the moment, I am doing this because of, or if they confess thereafter, and to be frank, I don't know the particulars of the exact circumstances between in that moment. It's really early that a lot of this information is not public. But look at the circumstances of the Boston Marathon bombing. As they were investigating it, they looked into the Tsarnaev brothers' background, how they had been radicalized when they went abroad. They came to recognize that this is the motivation beyond just in the moment, this was a marathon bombing. It was horrific, but what is the reason why? Unless he said something in the moment, and this is probably part of the reason why they don't immediately rush to judgment and charge it, they're going to do that investigation. They're going to talk. And the Boston police have excellent detectives, investigators, who I'm sure will be talking to these individuals, looking at social media posts, potentially doing search warrants as part of the grand jury process. And right now, unless there's something explicit, it's circumstantial. When I say circumstantial, it's not concrete. It seems like it might be, but it's not. But if it's a circumstance that they interview, they find that this individual is doing social media posts, and we'll get stuff with the Capitol Hill riots, we'll get stuff involving the Tsarnaev brothers, Dylan Roof in South Carolina. As they do that background, they look into these individuals and they see they might have made posts or made jokes that weren't just in poor taste, but show that this person had a bias, had an animus. That's information they would present, which is still potentially circumstantial, but it gives more reason as to why did this happen? Why would this individual on that day? Because it's not just he had a knife on him, which he might have otherwise. He had a gun. He had a gun for a reason. Did he specifically go to that synagogue because, and are there social media posts about it? Did he target that synagogue? Did he target that person? Or was it just a circumstance that he was in the area, but he made the affirmative decision to go with a gun and a knife and to go to this individual, this rabbi, and potentially to seek to kill him, and potentially others to be determined. If they are able through their investigation to show more and more circumstantial reasoning why this is likely something that was specifically motivated by an animus towards the Jewish people, they are much more likely to both be able to charge it, because again, to charge is probable cause. It's a low standard. But to prove it, which is to beyond a reasonable doubt to a moral certainty, the highest standard that there is. So it's absolutely the circumstance that information plays into it. And I wouldn't be terribly surprised if they're investigating that now, let alone if this individual made any statements or otherwise at the scene, because I would bet there's some cameras in the area. My understanding is he had the gun out, but he only put it away when onlookers were nearby, or when or at least also with the stabbing. That will factor into where this ends up.
Okay, interesting. In terms of the let's just like take a step back and talk about general anti-Semitism. A lot of association with Jews being associated with the shared national heritage of Israel has resulted in targeting of Jews on the streets of all over the country, actually, unfortunately. And what are your thoughts in terms of that being classified as a hate crime? For example, there were a number of people in New York shortly after the escalation, the war that Gaza, launched thousands of rockets at Israeli civilians. and the Israeli Defense Force responding to those rockets. That caused a whole tumult in the streets of New York City, in LA, all over the country. One of the things that we saw on social media, for example, were people accosting verbally, minimally accosting verbally, Jewish people because of Zionism. And so what are your thoughts in terms of that being classified as a hate crime? First of all, there is some ambiguity in terms of Judaism and Jews being classified as a race versus a religion. And then second of all, when it is, when they're being attacked for being Zionists or some, equivalent of Zionism, pro-Israel, whatever it is, Jewish, when they're being attacked, at what point does that cross the line? Is it, like you mentioned before, assault and battery? Maybe break that down for us, because a number of people on the streets here and elsewhere, Philly, have been verbally accosted for being Jewish, specifically as it relates to Israel. So is that enough to call it a crime? And would it then be called a hate crime? What are your thoughts on that?
So what I would say, and to clarify on that statute, it's whoever commits an assault or a battery upon a person or damages the real or personal property of a person with the intent and due to the protected class. Obviously, with this individual who tried to kill the rabbi, we're talking assault or battery. Again, assault is an attempted battery. A battery is actually the physical touching. So what the circumstances you're describing, obviously, if there's physical touching or someone's afraid of being touched, meaning someone is holding up their fists or something along those lines, or even if they don't take a swing, if the person believes and is apprehensive of it, it's a hate crime, if that's the reason. If it's a circumstance that someone vandalizes the property, meaning, graffiti, damaging windows or otherwise, in Massachusetts at least, that is a hate crime. I can't speak to the statutes in New York or California, or even specifically on the federal one, but hate crimes we're talking criminal actions or a criminal violation. There's also a civil statute related to it involving the Attorney General's office, but that's more monetary. This is criminal punishment, possibility of jail time.
So just yelling racial slurs at someone does not constitute a crime.
So then it wouldn't necessarily be this statute. The question would be, is it a threat? Because, the Fifth Amendment exists. And I'll give you an example of that. Something happened in Narragansett, actually, Rhode Island. The Coast Guard House, which is a restaurant there, it was in the news recently, where a individual was at the Coast Guard House at this restaurant, and a family was there, an African-American family, and the person seemingly out of nowhere just started yelling at them, specifically because they're black, and no reason, saying they didn't belong there or something along those lines. It went to trial recently. And in that circumstance, I believe the individual's attorney said First Amendment, freedom of speech. The person was charged related to whether it was a threat, but also disturbing the peace. I believe the person was convicted on the disturbing the peace aspect, which has to involve causing a public inconvenience or public issues. So if someone's outside, you think of someone's at a crowded theater yelling fire. First Amendment is implicated, but it is still a crime if it causes uproar with other individuals. But disturbing the peace, disorderly conduct, is in Massachusetts at least a minimal offense. Maximum of fine, that's it. It is a crime, but if it's a first offense, it's a maximum of fine. If it's a subsequent offense, meaning you've been previously convicted of it, then you can get up to 6 months in jail. If someone's actually threatening someone, saying, I'm going to get you, I'm going to beat you up, and then use as a racial epithet, to me, that is a threat to commit a crime. And it's obviously motivated in some capacity related to the race or religion, and that would also potentially get up to the level of this hate crime, because it then could be conceived of as an assault. If it's a circumstance, someone just says, you are a blank, and it's a racial epithet or something along those lines, that wouldn't be a hate crime unless it resulted in something. If it then led to a public tumult, people screaming, people yelling, like yelling, fire in a crowded theater, that could be considered a crime. the motivation obviously would be due to the race or religion, the animus, but it wouldn't necessarily implicate one of these more serious statutes, at least in Massachusetts. Would I personally consider it a hate crime? Absolutely. But does the statute consider it a hate crime? Only if it rises to the level of an assault would it fit this statute. But there's other possibilities where someone could be charged, such as disturbing the peace. Because if someone's yelling stuff and it leads to all people yelling back and forth, that's a crime. It's just disturbing the peace. It's just a relatively minor crime.
Interesting. Okay, so basically, just to summarize thus far, on Friday when it wasn't arraigned as a hate crime, that's because the investigation is ongoing. They want to make sure before they call it a hate crime that it actually is enough evidence, that there's enough evidence to support that assertion, because otherwise they would have to walk it back, which could be damaging to the case. And the hate crime is essentially something that has to be assault or battery, and verbal accusation is not enough. It would have to actually result in some sort of damage or attempt to damage for it to be considered assault or battery. And it would most likely have to be within the act of doing the damage or attempting to do the damage. Otherwise, there might be circumstantial evidence, such as internet posts or various other background and circumstantial factors that might contribute to a classification as a hate crime. But without the evidence supporting it, just the fact that a person is a person of a particular protected class, whether it be a priest, an imam, or a rabbi, or whether it be a person based on gender, but in this particular religious class, we'll say, sitting on the stairs of a synagogue, that's not enough to classify it as a hate crime, because we don't know what the true motivation was by the perpetrator when they committed the assault and battery.
In general, I would agree without knowing more. Again, the police and the DA's office obviously know a lot more information than we do. I don't know the particulars of what this individual was saying to the rabbi. If he was saying certain things that would suggest that he is doing this or wants him to come, if he said, come, I'm not going to say anything, but if he sort of, come with me and make some kind of comment related to the fact that would be considered anti-Semitic, I think that would be obvious that was the reason there would be a basis to charge. I don't know the particulars on what was said, and frankly, some of that is starting to come out in the media, but obviously the police and the DA's office know more. The concern with walking it back is you stand up to the community and you say, this is a hate crime. And you say, we're prosecuting as a hate crime. You don't want to, in 2 months, then say, never mind. Because if you bring out all these charges against the individual and the one missing is the hate crime, that's what's going to be the story. And that's what's going to have to be explained.
So that's more of a political consideration, less of a legal ramification.
I think it's both, because one, they'd have to have probable cause. I can't say whether or not they had a probable cause at that early stage, that this was motivated specifically due to the rabbi's background. If they didn't have probable cause at the time, they had suspicion of it, which I'm sure everyone agrees there's suspicion of it. But if they didn't have probable cause, technically the clerk cannot issue the charge against him for it. And if they thought they did have probable cause, but they wanted to do further investigation before standing up and saying this is a hate crime, then they're going to defer to the police and the DA office investigators to do that investigation through the grand jury process to make sure that they get that right before they actually charge it. Because one, they're not trying to make things easy for this individual. They don't want to give him a legal out to later say, obviously, he did what he did. And they're exceedingly serious charges and almost killed a man. But they don't want to have him be able to say thereafter, his lawyer, this would, there was a jump to overcharge or to draw conclusions. They don't want to give him any benefit of any doubt. They want to make sure they get this right. and they want to make sure they get it right based on evidence so they can prove beyond reasonable doubt. It's very different probable cause. They could always charge something, and if something doesn't eventually have beyond reasonable doubt and it's a not guilty, it is what it is. But if it's a circumstance they charge something, especially in a case where it's potentially international interest and exceedingly serious ramifications to the local community and specific to the rabbi, if you charge something and you then later are unable to prove the charge that really is what gets the public's attention, which has to do with the hate crime aspect of this, especially with the rise in anti-Semitism in America, then that is what the story is going to be. And that is also going to be a lot of the circumstance that's discussed. So they probably want to make sure they get that right before they charge it. They don't want to make sure they just have probable cause. They want to make sure they have more than just very minimal circumstantial evidence, but much more, so that they can confidently say, and the DA and DA Rollins can confidently say, we are prosecuting this as a hate crime because we believe we can prove it.
Great. So let's shift gears a little bit if we still have some more time. Can we talk about just the fact that it is a rabbinic leader on the stairs of a synagogue? Is there no extra protection in 2021? Is there no extra protection for those circumstances where a person is, that itself, in other words, can that itself be considered circumstantial? And if not, why not? Let's try to unpack that a little bit, because it seems in light of the rise in anti-Semitism that if a person is sitting on the stairs of a church, they happen to outwardly be wearing the priestly garment, whatever it would be, or an imam sitting on the stairs of a mosque, or a rabbi sitting on the stairs of a synagogue, it would seem that there is an outward connection to that particular category of protected category under the statutes. Why is it that this wouldn't be immediately considered a hate crime? In other words, it seems that in a time, especially with anti-Semitism spiking, just climbing absurdly, that this would somehow offer a little bit of extra protection and put fear into people that are looking to, raise havoc and not just disrupt the peace, but actually cause damage and create wars internally in the United States.
Basically, why not just stand up there and say, this is a hate crime, this is obviously a hate crime, and I stand with the community?
Well, yeah, if you see a rabbi-looking fella, or some religious person, sitting on the stairs of a religious place of prayer, they should be protected. There should be some level of legal, additional legal ramifications for accosting them, even verbally. To start assaulting people, whether it be verbally, whether it be physically, why isn't there extra protection for people, no matter what it is? But it's like the circumstance. It's almost like if you go to a parade, and the parade is espousing they're standing up for a certain gender or sexual orientation, and then someone attacks someone at that parade. It would seem like that seems like pretty circumstantial evidence that this was a hate crime, but because they didn't say you so-and-so, that would not constitute a hate crime. And to me, that just seems absurd. You're at the parade, everyone knows the parade's going on, and this person just ran over and beat up some random person at the parade that was clearly associated with the parade. Why isn't that a hate? Why would that be a hate crime? What would be the difference? Just speak that out.
And I think another parallel, think of the Black Lives Matter, the protests where, the individual ran over people, and it was everyone just presumed immediately, as you should, that this was done for that reason. Why else would this wasn't an accident. This was done purposefully, maliciously, specifically because of the reason these people were there protesting. And circumstantial evidence is basically evidence that is not, the example they give in court is essentially if you're outside and you see, you don't see the mailman, but there's mail in your mailbox, it's circumstantial evidence the mailman was there overnight or was there earlier in the day. That's obvious. The circumstantial evidence here, obviously being he is a rabbi wearing all the hallmarks of being a rabbi, sitting on a synagogue, on a synagogue steps.
Got a big menorah in the front yard. I mean,
as obvious as it can be, without wearing a sign that says "I am a rabbi." And I totally understand that, and I can't speak for the DA's office specifically. My presumption, based on my experience, would be that they just did not want to, without having conclusive evidence. Given the DA went to the arraignment, or at least was virtually there on Friday. She went to the vigil. I think she's making it very clear that she stands with the community and is taking this case very seriously. This individual will be held without bail. Has the hearing on Thursday, on July 8th, to further have him held during the pendency of the case. I think, and it is the circumstance, obviously, with the community and otherwise. You want people, the public figures, you want the police and otherwise to stand up there and call a spade and say this is what it is, and we are here to both prosecute it and to stand beside you.
Yeah, sorry to interrupt. I'm not in any way criticizing the DA or the DA's office. I'm simply looking more procedurally. Like it seems that there is a need for circumstantial evidence, strong circumstantial evidence. But again, the case of the Pride Parade, would that be enough? Have we seen cases where it was considered a hate crime? It would seem that the answer would be yes. Maybe the answer is no. That really also isn't enough. But I just wanted to hear your thoughts in general in terms of procedurally, where the distinctions lie.
You think of the obvious thing, and there are cases that are pending in Massachusetts like this, where someone's having arguments over Black Lives Matter, someone without even saying a racial epithet, without using the N-word or anything like that, but it has comments in the context of Black Lives Matter protests and results in someone assaulting someone. That is considered a hate crime because of the context of the conversation, what is being discussed. And
even though they didn't call them a specific word or make any indication that it was because they're part of the Black Lives Matter protest, but that would still, because it was at a organized event for Black Lives Matter, that would be enough to consider it a hate crime?
It should be enough, at least for probable cause, but then people want to look into the background. And the background has to do with not just social media posts, but why. Obviously, crimes occur in settings which would seem obviously hate crime. There are crimes, there are people who are at parades, they get to argument with someone not because of the racial makeup of the individual or the gender or the orientation, but because of alcohol or just because of one-on-one issues, and fights ensue. Doesn't make everything automatically a hate crime. They need to verify that the motivation of the person is due to that. And so
it's a judgment call. Basically, you're saying it's a judgment call based on what the actual prosecutor believes will be held in will be upheld in the court of law.
Yes, and I would certainly suggest it's easier, like, to give you an example of the charges against this individual. They charge assault and battery with a dangerous weapon causing serious bodily injury. Serious bodily injury is an impairment of a bodily function. Being stabbed and having injuries to your arm is bodily injury. Sometimes there's a circumstance where that charge is made where the person's had just been in the hospital. They don't really know the extent of the injuries. Whether or not it can hold up at the end versus being charged is different. But they're more inclined to do that on routine charges. Given the not just the spotlight on the circumstances involving the rabbi, but there is often not a rush as much as the media and people and individuals who are involved want there to be. This is clear. Stay what it is. Why are you waiting? It's often the circumstance that the individuals who are involved in making these decisions want to have more than just the very routine. Because if you call something a hate crime and you say this is the reason, even if it's obvious just on the surface, without getting the particulars. And it turns out it is an individual, just to give an example. I'm not saying that's what this is. If this is an individual having a mental health crisis who sees a person and that's who he picks on, and it's not anything due to the race or religion, but it's just someone who is having a mental health episode and they target the person, that wouldn't be a hate crime.
But isn't that the job of the defense and has nothing to do with the charge, right?
It's the job of the defense at a trial. It is
right. So why would the prosecutor need to determine the mental health of the perpetrator?
They don't need to, but I'm talking about in terms of charging someone, they require probable cause. And if it's a circumstance that the only information presented for probable cause is there's a rabbi sitting in front of a synagogue and that's it, I would bet most courts would say that is probable cause. But if that's the extent of the information, I would expect they would want more than just that. So it's not the circumstance that I'm saying, that is the defense's job to point out, look, there's mental health, look at this, look, this is criminal responsibility, medication, hearing voices. That is 100% the defense job. And the prosecution should in no way consider that initially. But if it's but they need to have something. And maybe they didn't have it on Thursday night before Friday morning, and they might already have it now. And maybe just this, they could always take out new charges. Maybe this week, additional charges, including the hate crime charge, comes out before July 8th. I can tell you, I looked up, there's nothing pending right now that's new, but they could take out new charges in the next week if they have more conclusive information. I guarantee you at this hearing on July 8th, there'll be more information presented that should hopefully shed a little bit more light on the background, because the DA's office needs to show that this person is a danger and there are no conditions that could assure the safety of the community. Is the community everyone? Is the community the Jewish community? So there might be more information that comes to light that makes it much more clearly that this was motivated by anti-Semitism and because the rabbi is a rabbi. And if that's a circumstance, what if there's social media posts that this person's talking a lot about school shootings and harming kids, and about how subscribing to different social media channels that say these things aren't real or false flag operations. This gives more of a reason to say he's targeting not the rabbi, but he was targeting the temple. And that's much, I'm not saying that's, arguably that's worse if he intended to do more harm, and this rabbi is even more of a hero because he stopped that.
Got it.
They might already know it, but they might not have known it Friday morning.
In terms of sending a clear message to potential criminals, again, the context of 2021, here we're in the summer of 2021, anti-Semitism has been on a rise for years. After a recent Gaza-Israeli war, we've seen a large increase, specifically against Jews, because they're Jewish, and therefore by association they are Zionists. They're being called Zionists. Some people are claiming that Zionist has replaced the word Jew, and that anti-Semitism, anti-Zionism is the new anti-Semitism, et cetera, et cetera. Is it important to send a clear message to the bad guys who are going to, who are accosting, who are physically assaulting and verbally accosting people of religion, for their religious backgrounds or their race, whether it's Israeli or black or whatever it is? Is it important to send a very strong message and call this a hate crime? Because of the fact, I understand that it's a judgment call and that a person doesn't, the prosecution doesn't want to walk it back. But at the same time, does it become a sort of a weakness in the prosecution to not immediately call it a hate crime? And if again, like we said before, if a rabbi sitting on the stairs or a Jewish person sitting on the stairs of a synagogue being attempted, someone attempting to murder them, if that is not a hate crime, then what is? And so, what are your thoughts in terms of the dynamic of the image to the public when it isn't being called a hate crime?
So I think it is a circumstance. Absolutely, there are messages that can be sent, and they need to be sent. I think when the DA goes to the vigil, is present with the community. I think acting Mayor Janey was as well. They say, we're investigating this. Hate is no home here. That sends a message. I think another way to send a message, oftentimes, is a circumstance. We have these 7 charges now. Sometimes they wait until the grand jury process, assuming it's going to Superior Court, before they issue the new charges. And that could be 2-3 months from now. A way to send another message is if they have any evidence that's more than just the obvious, this is a rabbi in a synagogue. If they have it and they're prepared to charge it, don't wait. Don't wait through the grand jury process. File a new charge. They do it all the time. They can do it here. What they could do is, if they have it ready now, file that charge tomorrow. If they have more information, if they have video, more statements from the defendant Awad, if he made any statements that give you not just pause, but strong circumstantial evidence that this is motivated by anti-Semitism, charge him now, and then do a press conference or not, and say we are charging him now because this is a hate crime, and it was a hate crime initially, but we wanted to make sure we had more evidence beyond the obvious because we take it seriously. We prosecute hate crime seriously, and we don't want to call something a hate crime that might not be. Because that's, not to say, when you go into like the rape culture, any concern with the Me Too movement, you don't want to have the circumstance where someone says something it is and then it's not. Look at the Duke Lacrosse scandal. That does a lot of harm to victims and to people who really should be charged. And if they're ready to charge them, do it now.
So, just playing it forward, in this particular circumstance, it seems irrelevant. Like the hate crime is so minuscule compared to attempted murder. But where it would be more relevant would be if a person walked up to a synagogue, a Jewish person or a black person or whatever it is, and smacked them. The fact that could get a person 2 to 15 years, 2 to 15, right? 2 to 15 years if there was a weapon on him and things like this. But it could be a maximum, but it could get him 2+ years, 2 to 15 years in prison will hopefully, put a little fear into the anti-Semites or racist people and prevent them from doing these things. So in this case, we're talking about attempted murder. It's dwarfed, that the charges of attempted murder dwarf the hate crime component. At the same time, to send a clear message is definitely important. So,
and I will tell you, think about it. He's not been charged with a firearm violation. I presume that means it's because he had a firearm identification card. He probably legally had that firearm. Otherwise, they would have charged him with carrying a firearm. Ways to send a clear message, some of which they have done. They move for dangerousness. Obviously, the rabbi was nearly murdered. Anytime there's a hate crime or an allegation of a hate crime, move for dangerousness. Seek to have that person held, saying if you commit any level of hate crime, we will move to seek to have you held without bail under the dangerousness statute. That's something that can be done unequivocally in each time. Most of these counties have hate crime prosecutors. I'm sure Suffolk County does. I know Norfolk County does. They have people with specialized training who take these cases seriously. It's not a case passed from one person to the next. That's the prosecutor, or that's the prosecutor who will remain on the case. Move for dangerousness, stand up there and charge the most they can do, and make sure to get all the evidence you can to marshal against this individual. Yes, the hate crime statute is up to 10 years. The other stuff he's facing aren't that much higher right now. It's up to 15 years in what he's facing now. There will be other charges that I'm sure they can take out that carry serious sentences as well. Make a point. Move for dangerousness. Move for dangerousness again in Superior Court. Ask for the judge to do the most serious punishment you can. Ask for the maximum that you can ask for, and make it very clear that if you are prosecuted, if you commit any offense like this, a hate crime in this jurisdiction, we will not offer probation. We will not agree to a low sentence. If the sentencing guidelines call for 5 to 7 years, we will ask for above it every time. That's something that you can send a clear message that you will spend more time in jail. It won't be the circumstance that you're posting $40 and going home. We will move to have you held. And if the judge doesn't hold you, that's up to the judge. but the DA's office won't stand by and let these individuals, because we'll say, if you're going to commit a hate crime on one person, you can do it on anyone else.
Mike, anything else you want to add?
I would just say, I think it's early in this case. I'm thankfully the rabbi is doing well. He is, I'm sure, been through a ton, and he's potentially heroically saved all sorts of other people's lives. I'm optimistic that the DA's office will prosecute this individual to the fullest extent they can. More information will come out in the near future, and ideally makes it even more explicit that this is a hate crime and he'll be charged as such. Thank you very much.
Mike, thanks for being on the Tribecast. It's important. The laws exist not just to punish the people who are, who are dangerous, not just to protect the public from the person who committed a crime, but also to deter future crimes. Thanks for unpacking this for us, for the Jewish community and for really everybody. The concept of a hate crime is somewhat ambiguous, and you really crystallized a lot of these important issues surrounding the hate crime statutes. Thanks so much for your time. Mike Thaler, thanks so much for being on the Tribecast. I'm JP Katz, and you're listening to Tribecast at tribejournal.org.